Good morning. I'm Judge John Stargell. I'm going to be presiding today. We have two oral arguments on the calendar, and for the first one, I'm joined by my colleague, Judge Jared Smith, and we have an associate judge with us today, Judge Thomas Palermo, who currently sits on the 13th Circuit, and we welcome you. Thank you for your diligence to be here.
Thank you all for having me.
Okay, our first case will be Corey McKinney versus Micah Graham, 23-2745. I want to remind anyone who's out there, please turn off your cell phones so that we're not distracted or turn them to vibrate. Yes, counsel, please approach and introduce yourselves or stand. Okay, so for Mr. McKinney, sir, you are.
Your Honor, good morning. My name is Peter Webster. I'm with Carlton Fields. My name is not on the oral argument calendar, but I did file a notice of appearance a month or so ago. I would like to try and reserve about 4 minutes of my time for rebuttal, if I may. I intend to focus primarily on our first issue, which is the...
All right, before we get started there,
Yes,
let's
sir.
get the party for Mr. Graham. Ms. Stein?
Good morning, Your Honors. Yes, Stein on behalf of Mr. Graham.
Okay, very good. Just wanted to get that on the record. Mr. Webster, you are recognized.
Thank you, Your Honor. As I said, I'm going to try to reserve about 4 minutes of my time for rebuttal. I do intend to focus primarily on the first issue, which is the propriety of the order striking Mr. McKinney's pleadings and defenses for fraud on the court. But I do want to point out, in case I don't get to it, that even if the sanctions order were to be upheld, a new trial would still be required because the trial court erroneously precluded Mr. McKinney from challenging damages causation, the extent of plaintiff's claim damages, and permanency, failed to bifurcate the trial and or directed a verdict for plaintiff on damages causation, permanency, and past medical expenses. All three of those would require a new trial regardless of this court's ruling on the propriety of the fraud on the court order. So, with regard to fraud on the court, assuming everything plaintiff alleged in his motion for sanctions is true, it doesn't warrant the most severe sanction of striking Mr. McKinney's pleadings and defenses, and the order doing so is a clear abuse of discretion. In his motion, plaintiff relied on supposed misrepresentations by McKinney regarding Mr. McKinney's alcohol consumption before the accident and his assets. As to the former, plaintiff asserted that McKinney misrepresented his alcohol consumption in an answer to the first set of interrogatories and in his deposition, saying that he'd had only 3 beers. What plaintiff's motion failed to state, however, is that 16 days after his deposition, in nearly 2 years before the first trial in 2018, McKinney responded to requests for admissions, admitting that he was under the influence of alcohol, that he failed a field sobriety test, and had a blood alcohol level between 0.281 and 0.270, and also admitting that plaintiff was entitled to recover punitive damages. Plaintiff published those admissions to the jury during both the first and second trials. In fact, before the first trial, defendants admitted liability and that if the plaintiff was awarded compensatory damages, he would also be entitled to punitive damages. Plaintiff also published those admissions to the jury during the first trial and the second trial. Thus, any early misrepresentations about alcohol consumption could not have possibly improperly influenced the jury or had any impact whatsoever on the outcome of the trial. And they certainly don't amount to a deliberate scheme to subvert the judicial process. Accordingly, to the extent the trial court relied on these supposed misrepresentations in reaching its decision, doing so was a clear abuse of discretion. In fact, it's impossible to say what the trial court relied on because the order, although it repeatedly refers to, quote, lies on Mr. McKinney's part, never identifies any specific examples of those lies. And I might point out that the order was drafted by plaintiff's trial counsel and was signed by the court without any changes. On appeal, the plaintiff doesn't even try to argue that the supposed early misrepresentations about alcohol consumption support the sanctions order. He relies exclusively on alleged misrepresentations by McKinney in response to interrogatories relating to assets. However, these also fail to support the sanctions order, except in the most extreme cases where it appears that the process of the trial itself has been subverted. Poor recollection, dissemblance, even lying can be well managed through cross-examination. The fifth DCA, which was the controlling court at the time this motion was heard and the order was entered, has repeatedly held as much. It did so in Villasenor versus Martinez, a 2008 case, and also in Bologna versus Schlanger, another 2008 case. Here, assuming that all of plaintiff's representations regarding McKinney's responses to assets interrogatories are true, and none have yet been proved, they would not come close to an attempt to subvert the judicial process. In his brief, plaintiff points to a limited warranty deed, a mortgage and other loan documents, social media postings showing McKinney leading a happy life, and a deposition from McKinney's supposed former employer that plaintiff claims confirms that Mr. McKinney was employed full-time when he answered the interrogatories. The materials related to the house establish only that it was in Mr. McKinney's name and that it was subject to a mortgage of roughly $169,000. They say nothing about net equity, if any. Moreover, the deposition of his former, quote, employer actually establishes only that during the 9 months preceding his July 2022 termination, Mr. McKinney made roughly $4,438 as an independent contractor, and the social media postings add absolutely nothing. The same is true with regard to the surveillance videos that plaintiff's trial counsel made a big deal out of at the hearing on the motion. In fact, the videos and the information relating to them were not even filed with the court until 2 months after the sanctions order was entered. There's nothing to remotely suggest that any of the so-called misrepresentations would change the fact that McKinney had a meager net worth, and therefore nothing to suggest that any aspect of the trial would have been subverted, assuming all of the alleged misrepresentations were true. They would have been pertinent only to the punitive damage claim, having no bearing on compensatory damages. To the extent any of the plaintiff's contentions are in fact correct, they could have been easily handled by cross-examination and, if necessary, by impeachment. Because no reasonable man could conclude that McKinney's alleged misrepresentations about his assets were sufficiently serious to merit imposition of the most extreme sanction of striking his pleadings and defenses, the trial court abused its discretion when it did precisely that. We maintain that for that reason, this court should reverse and remand with directions that the pleadings and defenses be reinstated and that a new trial be held. And I would like to point out to the court that we filed a notice of supplementary authority on Tuesday regarding a January 8th, 4th DCA decision, Zufi, Z-U-F-I versus Stockton. And we believe that case, it provides strong support for the
The citation there?
The name is Zufi.
Yes, I've got that. Do you have the site?
Yeah, the site is 2025 Westlaw 45262, and it's a January 8th, 4th DCA decision.
Thank
We believe it supports our argument that that this court, because no evidence was taken in the trial court, sits in a position equivalent to the trial court, owes no deference to the trial court's determination regarding fraud on the court, and it is essentially able to make its own determination regarding whether the plaintiff proved by clear and convincing evidence that it was entitled to imposition of the most severe sanction. But
So
in
your position on like the $4,400, where he said he wasn't working because he was working as a 1099 employee and just doing odd jobs for his, that qualifies as odd jobs because it was just on a commission basis and doing a few things here and there.
Even if that was a misstatement, it's certainly not the type of misstatement that the courts have repeatedly held is required before you can find a deliberate attempt to subvert the judicial process.
And the same with the residence. He said he didn't own a home, but he owned one with his wife. But you're saying there was no equity, so in essence, he was being truthful, or that it's just not enough of a lie to bear it.
Again, this would go only to punitive damages. So assuming all of the misrepresentations plaintiff is complaining about were true, and we don't know that at this point because no evidence has actually been presented. But assuming that they're all true, it doesn't change the fact that Mr. McKinney had a meager net worth, and to the extent they wanted to prove, plaintiff wanted to prove it was more than Mr. McKinney claimed it was, they could have done that easily through cross-examination and impeachment. So we think we're entitled to a new trial because they didn't prove by clear and convincing evidence that they were entitled to have the pleadings and defenses stricken. But at an absolute minimum, it's the overwhelming weight of authority, particularly from the 5th DCA, which was controlling at the time this was presented and ruled on, but frankly from all of the appellate courts in the state, is to the effect that Mr. McKinney was entitled to the evidentiary hearing he repeatedly requested. The trial court didn't grant that request for an evidentiary hearing. Plaintiff on appeal says that Mr. McKinney's complaint about the denial of an evidentiary hearing might be well taken if he had objected to a non-evidentiary hearing in advance. But the fact is that Mr. McKinney expressly requested an evidentiary hearing in his response to the motion for sanctions, which response was filed before plaintiff noticed a hearing for a 30-minute non-evidentiary consideration. We cited a number of cases for the proposition that Mr. McKinney was entitled to a hearing. Perhaps the one that's most particularly noteworthy is the Villasenor versus Martinez case that we cited in our briefs, 2008 5th DCA case, virtually on all fours with our case. Plaintiff contends in its brief that it's distinguishable because the non-moving party there supported her opposition with an affidavit disputing the movement's claim for fraud. It's true the court did mention in the Villasenor opinion that the non-movement had filed an affidavit, but nothing in the opinion remotely suggests that the court considered that affidavit relevant for purposes of its legal analysis. In fact, the only substantive distinction between that case and this is that the opinion there does not indicate that the non-movement ever asked the trial court for an evidentiary hearing. In Villasenor, the court held one is the burden of the party alleging fraud on the court, warranting the most severe sanction, to establish the same by clear and convincing evidence. Two, meeting that burden will almost always require an evidentiary hearing. And three, documents attached to the motion to dismiss but never introduced into evidence could not be considered in support of the motion. The court in Villasenor reversed the order dismissing the plaintiff appellant's complaint with prejudice for fraud on the court and remanded for an evidentiary hearing. Villasenor, on which McKinney relied repeatedly in the trial court, is, as I said, we think particularly noteworthy because plaintiff's trial counsel here, Mr. Byrd, also represented Ms. Villasenor. And as McKinney's counsel pointed out in the trial court, Mr. Byrd in Villasenor successfully made precisely the same arguments that we made in the trial court and that we're making here on appeal. So at an absolute minimum, even should this court conclude that plaintiff did not fail to carry his burden in the trial court, and that there was clear and convincing evidence, at an absolute minimum, we're entitled to a remand for the evidentiary hearing that we requested. So with regard to the other issues, regardless, even if this court upholds the ruling on the sanctions motion in its entirety, a new trial is required. First, because the trial court erroneously precluded us from challenging damages causation, the extent of claim damages, and permanency. Second, because it failed to bifurcate the trial. And third, because it directed a verdict on damages causation, permanency, and past medical expenses. I'm not going to say much about damages causation, extent of damages, and permanency, other than to note that we cited several cases in our briefs for the proposition that even defaulted parties are entitled to present evidence on that. In Tolucci versus Matthews, a fourth DCA case, 2007, the court said, and I quote, "For more than a century, it has been the law in Florida that a defaulted defendant has the right to contest the amount of unliquidated damages and may offer evidence in mitigation thereof. The right to contest unliquidated damages in any negligence action encompasses the right to challenge the causal relationship between the damages claimed and the liability established by the default." In fact, the sanctions order, I see that. In fact, the sanctions order that Mr. Byrd prepared expressly states that McKinney is still entitled to contest the amount of claimed damages causation. At page 5863 of the record, the order says, "This trial will proceed on a determination of the amount of damages thus caused by plaintiff." The successor judge just simply misread the plain language of that order. And with regard to bifurcation, and I'll finish up with that, nothing had changed in this case. Liability had still been admitted, and according to the fifth DCA's decision, we were still entitled to a bifurcated trial at which no evidence regarding intoxication would be presented during the compensatory damages phase, because to do that would only serve to impermissibly inflame the jury. And obviously that's what happened here, that the compensatory damages are beyond comprehension. Thank you. I'll reserve the rest of my time.
Ms. Stein, you recognize.
May it please the court, Dinah Stein again on behalf of Mr. Micah Graham.
I'd like if you could start where he just left off with the fifth DCA's decision and the bifurcation, and when it is that a trial judge can look past or reverse what's already been set out in a case and decided by an appellate court.
Thank you, Your Honor. When the remand is for, in this case, it's for a new trial on the damages. It's what was tried the first time. That was what was at issue. Mandates mean that whatever was stated in the decision is the law of the case. You don't change from that. But they don't address when things change. In other words, there are many cases out there for various reasons when there's a new trial ordered, perhaps it's on all issues because of an evidentiary ruling, let's say. That is not to say that if on remand that one of the parties does something sanctionable, that the trial court is now powerless to look at issues that were not addressed the first time around.
This wouldn't have been powerless, though. It's a question of the extent of the judge's ability to sanction to certain levels versus erasing something that the DCA had sent back for them to have a bifurcated hearing.
Well, the DCA sent it back because it was bifurcated. It held that when there's a bifurcation and an admission of liability, this is based on the other cases holding the same thing, that the talking about intoxication in the compensatory portion, it's just irrelevant. There's no reason for it because you're going to get to that in the second phase of the bifurcated trial. The Fifth District never held that a case must be bifurcated. It cited to W.R. Grace, the Supreme Court case. There was a discussion about that. It went through what that case stood for. W.R. Grace says upon a timely motion, there should be a bifurcation. But W.R. Grace does not say bifurcation is a fundamental right. It doesn't say it's necessary. It doesn't say it has to be done if no one asks for it. So I would submit that the mandate was when you have a bifurcated trial, you don't bring intoxication into the compensatory part. It didn't say if there's a sanction, things don't change. And I would submit.
Well, and help me with my reading of it and just the second head note of the second column, what I'm looking at is the case. The Florida Supreme Court has determined that bifurcation is proper when both compensatory and punitive damages are at issue. So walk me back through how that's different and why they didn't see this as something that would happen on a remand.
That they're citing to W.R. Grace. W.R. Grace, in fact, it had addressed bifurcation for different issues, but it said in that case, we're talking about corporate defendants who are able to mitigate punitive damages by showing that they've had other punitive awards or net worth, those types of things. And they said in W.R. Grace, we shouldn't have to force defendants to bring that into the compensatory part. This is where the Supreme Court said, we here to, from now on, find bifurcation is proper upon a timely motion. There's no mandate in the state of Florida where bifurcation is always going to be required. That's why we've cited to the Humana case, which said that the sanction obviated the need for bifurcation. In other words, once there's a sanction, the trial court has broad discretion in dealing with it. And there was no mandate that said on remand, you must have a bifurcation. It just said, when you have a bifurcation, this is how it's done. So Judge Thompson had the opinion available to him and held, and this isn't part of the mandate. So again, the mandate was not that specific. The mandate talked about when we have a bifurcated trial, this is what the appellate courts, the district courts have done. We're adopting that law now. That's what the Fifth District said, that when there's a bifurcation, there can't be evidence of intoxication in the first part. But again, I would submit that it's just like when there's a new trial based on, let's say, improper evidence, and it's remanded for a new trial, and then there's a sanction. The court has broad discretion to impose sanctions. And this is, again, not something that the defendant has a right to. And when they are sanctioned for fraud on the court, they lose significant rights. So I would submit this is well within the court's broad discretion in addressing the sanction, which, remember, this is a situation where we did have an admission of liability. The defendants have taken a position essentially that the sanction should have amounted to next to nothing, that it should just be a striking of liability. I mean, if we took defendant's position, there'd virtually be no sanction. He'd get a free pass. He'd be able to lie about, which I'll get to, about his assets, and there'd be no recourse because he has already admitted to liability. I mean, that's essentially what defendant has been saying is, that's enough. At some point, courts have discretion to deal with sanctionable behavior, and I would submit unbifurcating a case when there's no mandate and no right to it because you've waived that right by lying about your assets, which directly go to punitives, you lose that right, and it's not part of the mandate. But I do want to, yes.
He lied about assets, right? And that goes to punitive, fine. How does eliminating the firewall between the compensatory damages and the punitive damages, the inflammatory nature, if you will, the intoxication, how does that fit with what you're suggesting is an appropriate sanction for the conduct that you're saying he committed?
So, and defendant is really downplaying that conduct. I mean, this
I'm
is
not worried about how he's down.
Right.
I want to know how you can
Yes.
justify inflaming the jury on compensatories as a reasonable sanction for bad behavior associated with the calculation of the punitive damages.
the cases that address intoxication do it in a very limited circumstance. It's when there's an admission of liability, and admission of punitives.
But you have an admission of liability here.
Right.
And look, if I'm receiving that 50 CA mandate as a trial judge, I certainly would react to it as if the 50 CA clearly is telling you to bifurcate. So I'm not interpreting it quite the same way you've interpreted it. So I'm not tracking how his bad conduct on facts and evidence associated with the calculation in the end of the punitive damages would justify what is in essence pouring gasoline on the compensatory damage calculation. How does that fit?
Well, it's no different than any other case where there's a bifurcation, but the jury still has to consider the right to punitives or whether there will be punitives in phase one. But just by nature of it, they're always going to hear inflammatory evidence. Now, there's been the line of cases that say if there's an admission,
You're saying that we're compensatory? They're always going to hear that?
if there's a bifurcated proceeding where there's not an admission of liability or punitives, the first jury determines whether there's an entitlement to punitives. So by nature, it's going to come in.
But that's not the scenario in this case.
It's not the scenario in this case for the sole reason that there was an admission of liability. But other than that, it's the same scenario. In other words, juries are able to distinguish the punitive evidence. They do it in every trial. They are determined. They're to be able to not have to, to not be inflamed, to separate compensatory and punitives. They do it in just about every trial, except when there's an
Do you think they
admission.
really did that here, where the jury gave more damages than what the plaintiff was even asking for?
They
Don't
actually,
you think that textbook says that what you all did accomplished the exactly what's not supposed to happen?
Your
in a
Honor,
trial?
yeah, not at all, not at all. And we've made this very clear and I think it actually goes in favor of our argument in that the jury did exactly what plaintiff's counsel argued very methodically about the compensatory damages. I mean, he came up with a formula based on Mr. Graham's testimony as to how many hours a day he spends with each category of non-economic damages, and said, 10 hours a day, pain and suffering, 2 hours a day of inconvenience, and plugged in minimum wage to that and said, but this is the minimum, it's the floor, you can give 3 times that amount. And the jury did not. The jury plugged in $15 an hour instead of the 30 or what have you, which Mr. Byrd suggested. It's, I don't think a coincidence or an accident that they came up with that number when defense counsel, their sole purpose for that closing was to mitigate damages and didn't take issue with the number. And that's why I think that this was not an inflamed jury. They were giving no other mode to assess what to give. Defense counsel actually got up there and said, you don't have to give all damages, as if the damages that Mr. Byrd suggested were appropriate, and just started arguing that you can give, you could find that some of it wasn't caused by Mr. McKinney. So I would submit there's no evidence in this record that the jury was inflamed. They didn't give more than he suggested. He actually wanted
But
more.
The fact that McKinney didn't have effectively the right to offer mitigating evidence on the damages liquid.
Let me address, please, that, because he came to court the morning of trial, I don't remember when it was, with new evidence of mitigation. And part of the objection was that the plaintiff had never seen it before. This was new. So this, if it had been sent to opposing counsel perhaps beforehand, that might have been a different conversation today. But when he's already lied, I mean, there's no question he lied in these responses to the interrogatories. So he's now suspect in anything he gives. He didn't give these forms in response to the interrogatories or after he got sanctioned. So that was, a lot of the objection was just, we haven't seen this before. But there was no order that said, you could never come in and not mitigate. I mean, whether.
On one hand, we've added together the compensatory and punitive evidence in the single mass before the jury, and then limited the ability of the defendant in the case to challenge the evidence being used, in essence, to calculate the damages caused by his conduct and the additional monetary sanction that results from it.
He was not completely limited in challenging it. First of all, Mr. Graham always had the burden to prove the damages. The jury was instructed that, and he had to prove causation. The defense counsel got up after every witness on damages and cross-examined them and brought up whatever they can. And I say whatever they can because this is not one of those cases, and defendant keeps saying it. It's not a case where we had a prior injury. There was no competent evidence that Mr. Graham ever got in an accident before or was injured. They're bringing up things about I think his son maybe was in some accidents, but there's no, even on directed verdict motions, that wasn't brought up. There's no prior accident. So the issue was, did the crash cause what happened? I mean, we have a direct cause and effect. And did the subsequent accidents aggravate it such that the jury could take it out? That was the issue for the jury. And defense counsel very effectively got up with each witness and cross-examined them about those accidents, which came out. The jury heard everything. This was not like one of those cases, I think the ICMG case that the defense has cited to, where it's, essentially the plaintiff puts on a sham damages defense. I mean, that's what happened in that case, where the expert spouted off inadmissible damages testimony, and they said, that's not what sanctions are about. Here, Mr. Graham put it all out there. He talked about his accidents subsequent, and his experts and treating physicians fully talked about it. And the jury was instructed they had to try to take out those damages. They had to determine, Mr. Graham still had the burden of showing causation. So this was not something that was completely taken away from the defense at the end of the day. I just want to go though too, because again, when we talk
Counsel,
about,
before you move on, for better or for worse, on your part, you've got three trial judges or former trial judges sitting here on this bench. And one of the things that was drilled into us from the first day we went to New Judges College and all the way through as we read cases and took our continuing judicial education is that when you sanction a party, your sanction has to be related to the conduct. And there's got to be a connection between your direct connection between what your sanction is and whatever it is that that sanction is going to hit, so to speak. And in this case, I can't see it. I didn't really hear a direct answer when Judge Palermo asked you this question. I'm going to give you a second chance to maybe try to convince me on this one. How does his misstatements, false statements about, I didn't make $4,000, but I actually did. I don't own it. I don't own anything. Well, I actually do have my name on a house that has a $160,000 mortgage. We don't know what the net equity is in the house. How do those two statements that are clearly only related to the punitive damages case, how does that justify a sanction of dropping the wall between compensatory damages and punitive damages so that we then create an absolute risk that I think on the facts, I know you have a different view of it, but I think on the facts clearly shows by a jury giving a verdict higher than what the plaintiff asked, that it did affect the jury. But let's just say, whether we could or could not tell on the record whether it did, just even the fact it created the risk that that jury could be inflamed by hearing all this alcohol intoxication evidence in the compensatory side of the case. How could that, how does that sanction order, how does that crime, so to speak, that improper conduct justify dropping that wall? How can I do that as a trial judge? Connect that for me.
Right.
I don't see the connection.
And I think that's why Mr. Plaintiff's counsel put in he did originally not tell the truth about his intoxication. That went directly to liability. Defense keeps saying, well, we're good guys
But
because
that got you over the liability hump, right? I mean, that got all of his defenses struck and everything. So you got liability established, so to speak. So you won on that front. That's a great punishment for the crime. Okay, so let's just say, but I still don't see the wall dropping. I don't understand how him misstating some statements that we could argue about just how serious it really is, but forget the seriousness. Let's say it's appropriate that there's some sort of sanction that needs to be issued. Shouldn't the sanction be focused on the punitive damages portion? How does it now branch over into compensatory to the liability side? How does it justify dropping that wall? I'm still,
right, Your Honor.
I don't get it.
Well, let's say another aspect of this. And I think my point about the alcohol was that it was just it's a pattern. It happened even after the sanctions, which were not part of the sanction, but he was caught lying again because of the continuous. It was never going to end. But the asset interrogatories were related to punitives, but they were also related to collection on everything. I mean, if let's say we had gotten a
But
judgment.
that's post-judgment. Okay.
Right,
So then as a trial judge, then I get to punish somebody on the post-judgment side, but we're not at the post-judgment side. We
Right.
were at the compensatory liability side of the trial, where now we're factoring in punitive damages evidence.
That's right. That's right. It happened at the compensatory liability phase. That's when he chose to do it. It took months for us to even get the interrogatories back.
I don't.
And
Tell me how timing relates to it. I don't know. Tell me in the case law where that judges get to pick and choose where they place their sanction based on the timing of the offense rather than the substance of the offense. I think that's what seems to be your argument here. I don't know if the case law is. I would have loved to have had that to trial judge to say, well, you did it on January 1st, so therefore, everything that existed in the case as of January 1st, I just get to pick and choose where the punishment falls. I don't think the case law says that. Tell me that.
no, Your Honor, I agree. I don't think the case law says that.
All right.
The case law gives the court discretion. And here, it's just not the same as a regular case where there's been no admission of liability.
You say it gives us discretion, the court discretion, but isn't it somewhat constrained here by the existence of the 5th TCA mandate? This isn't like a case that's come afresh to us. We have this mandate from the 5th TCA. So if you're the trial judge on the bottom, isn't there something external that is different from the vast majority of the sanctions cases that are out there, because there is a 5th DCA opinion that does discuss the bifurcation.
If you go line by line through the 5th DCA case, and I understand the 5th District does talk about the ability to talk about intoxication, but it never addresses the right to bifurcation. And there's no law in Florida that says there's a right, an absolute constitutional due process right to bifurcation. And I would submit it's just on the spectrum of sanctions available in a court's discretion when they're faced with this on how to deal with this type of contumacious conduct. So my position is it's not part of the mandate. The mandate was specific as to evidentiary when we have a bifurcated trial. It didn't preclude quashing the bifurcation order. I am looking at the time, Your Honors, but
I'll
if
give you 30 seconds if you want to just sum up the rest of your argument.
Yes, Your Honor, and Your Honors, we didn't, I think it's just manifest that there was an intent to lie. A defendant has had now months to put in any counter evidence. They never did. It was practically a concession that he lied. We met our competent substantial evidence burden. The question is what discretion did the trial court have when someone has already admitted to liability? And I would submit there has to be a punishment for the crime, and this was within the court's discretion and not in violation of a mandate. We would ask that Your Honors affirm. Thank you.
Thank you. Interruption. You're recognized. I'll give you a little bit extra too if you need it.
Thank you, Your Honor. First, I'd like to point out that plaintiff just represented to the court that there were no prior accidents in this case. We pointed out in both of our briefs that Dr. Mahan, one of plaintiff's experts, testified to 4 prior accidents, and that's at page 17 of our reply brief. With regard to bifurcation, well, before we do bifurcation, let me talk about what we were prevented from doing. We weren't allowed to present any evidence to challenge the amount of damages causation, or permanency. We weren't allowed to put on our 2 expert witnesses, both of whom would have testified that the plaintiff's injuries were caused by other factors. So the plaintiff, the jury wasn't allowed to hear any of that. No surprise. Bifurcation, in addition to everything Your Honors have said, let me point out that the only reason the trial court that plaintiff gave for asking to have this case unbifurcated was that McKinney's pleadings and defenses had been stricken. The prior motions to bifurcate that have been granted are neither pleadings nor defenses. And so this case was in precisely the same position it was in after the first trial. It should have been bifurcated again. And finally,
In essence, you're arguing that those were stipulations of the parties that the court then on its own, with the request of one party, and then set completely aside.
yes, Your Honor. And finally, I want to read from Zufi, which is the supplemental authority. This is with regard to fraud on the court. The court at page *8 of the opinion said, because the trial court in this case did not conduct any evidentiary hearing to evaluate the plaintiff's credibility, same as here, the trial court was in no better position than us in determining if competent substantial evidence clearly and convincingly proved that the plaintiff had engaged in a scheme to defraud, meriting dismissal for fraud on the court. In Zufi, the court essentially held that it was in the same position the trial court was in to determine whether the plaintiff had presented clear and convincing evidence justifying the most severe sanction. because no evidence had been presented. We submit this court should do the same thing here and arrive at the same conclusion. Thank you.
Thank you, Mr. Webster. Thanks to both of you for your arguments. And we will stand in recess until 10:30.